Good morning. I'm Emerson Laktuan, and today we are discussing about the Indeterminate Sentence Law together with my classmates in law school. What is Indeterminate Sentence Law? Indeterminate Sentence Law, the Act number 4103 as amended on December 5, 1933, the purpose of this law is to uplift and redeem valuable human material and prevent unnecessary and excessive deprivation of personal liberty and economic usefulness. As a rule, it is intended to favor the accused, particularly to shorten his term of imprisonment depending upon his behavior and his physical and moral records as a prisoner to be determined by the Board of Determinate Sentence. Indeterminate sentence is a sentence with a minimum term and a maximum term benefits of a guilty person which that qualified therefore when the maximum penalty of imprisonment exceed 1 year. It applies both violation under revised penal code and special penal laws. The next reporter will report about the application of the indeterminate sentence law.
So thank you, Mr. Laktuan. According to ISL, the courts must determine two penalties, maximum term and minimum term, instead of a single fixed penalty. So Section 1 provides for the maximum term and minimum term for offenses punishable by the revised penal code and the special penal laws. So under the special penal laws, the maximum term shall not exceed the maximum fixed by such law. The minimum term shall not be less than the minimum term prescribed by such law, while under the revised penal code, the maximum term in view of the attending circumstances that which could be properly imposed under the code. The minimum term within the range of the penalty next lower to that prescribed by the code for the offense. So let me take it by giving an example. In the crime of homicide, under the RPC, the offender is sentenced to reclusion temporal. The maximum penalty under the Indeterminate Sentence Law is reclusion temporal, which reclusion temporal is a divisible penalty consisting of maximum, medium, and minimum periods. The guide for determining the maximum penalty is to determine the entire range of the penalty and to determine if there is a mitigating or aggravating circumstance. In pursuant to Article 64, when there is no mitigating and no aggravating circumstance, it should be placed at the medium period. Thus, the maximum penalty for the example above, which is homicide, is reclusion temporal in the medium period. So, in getting the minimum penalty, the rule is to simply get the penalty 1 degree lower from the maximum penalty without taking into account the mitigating and aggravating circumstance. Thus, the penalty 1 degree lower from from reclusion temporal without taking into account the mitigating or aggravating circumstance is prisión mayor. Prisión mayor now is the minimum penalty in our example. So, prisión mayor is also divided into 3 periods. Under the Indeterminate Sentence Law, it would be placed upon the discretion of the court on which period to place it. Thus, the minimum penalty prisión mayor is in any of its period. To better understand the provisions of ISL, illustrations on how they are applied will be discussed by Mr. Ambolode.
Thank you, Ms. Mamarinta. Now let us elaborate on how to determine the maximum penalty and minimum penalty for crimes punishable under the revised penal code. To determine the period of maximum penalty imposable under the ISL or ISLAO, we have to take into account the attending circumstances in the crime, whether there are mitigating and or aggravating circumstances. For crimes punishable under the RPC, the rules are provided under Article 64 and are elaborated as follows. When there are no mitigating or aggravating circumstance, impose the medium period. If there are mitigating circumstance but no aggravating circumstance, impose the minimum period. If there are aggravating circumstances but no mitigating circumstance, impose the maximum period. But if there are both mitigating and aggravating circumstance, you have to offset the effect against each other. For example, let's say if there are 3 aggravating and 2 mitigating circumstances, that's 3 minus 2 equals 1 aggravating circumstance, then impose the maximum period. Or, if there are 3 aggravating against 3 mitigating circumstances, that's 3 minus 3 equals 0, then impose the medium period. In determining the minimum penalty, the ISL or SLAO confers upon the courts in fixing the penalties the widest discretion that the courts have ever had. In determining the minimum term, it is left solely upon the discretion of the court to fix it anywhere within the range of the penalty next lower, without reference to the periods into which it may be subdivided. Ms. Kamama will discuss its application on complex crimes. Ms. Kamama?
Thank you, Mr. Ambalade. I will be discussed to you how is indeterminate sentence law applied in complex crime under Article 48 of the RPC. A complex crime is punished by the most serious offense and shall be imposed in its maximum period. Example of complex crime is estafa through falsification of public documents under RPC, falsification of public documents under Article 171 is a more serious offense punished by prison mayor than estafa under Article 315 punished by only prison correctional. Thus, applying into indeterminate sentence law, the maximum penalty for estafa through falsification of public document shall be prison mayor in the maximum period, and the minimum penalty shall be prison correctional in any period upon again the discretion by the court. Suppose there are one mitigating circumstances proven, maximum penalty would still be prison mayor in the maximum period in pursuant under Article 48. Even if there is a mitigating present, it should still be imposed at the maximum period. But if there is two mitigating circumstances and no aggravating circumstances are present, the rule here, if it is a privileged mitigating circumstances, it will impose a penalty by 1 degree lower but still placed at maximum period. Thus, the maximum penalty shall be prison correctional in maximum period based on our example. And now let us go back to Mr. Lactuan for the concluding remarks about indeterminate sentence law. Mr. Lactuan?
Thank you, Ms. Kamama. Okay, under this law, the minimum and maximum are specified. Once the minimum term is served, the prisoner becomes eligible for parole if he proves that he has complied with the condition imposed on him when he was made to serve sentence. Parole doesn't mean a person has fully served sentence. However, it means that he is allowed to serve the remainder of his sentence out of jail or correctional institution, but under the supervision of an appointed parole officer on appointed dates for the remainder of the prison term. Then, during the parole, the prisoner released on parole must apply himself to a legitimate occupation and prove himself to be a law-abiding citizen. His residence will be fixed and changed from time to time under the discretion of the Board of Indeterminate, Board of Pardon and Parole. The board can issue a final certificate of release if the paroled prisoner has proven himself to be a law-abiding citizen. If ever he violates any term and condition of his parole, he can be rearrested in any part of the Philippine Island and may serve his remaining term of his prison sentence behind bars.